The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear today is Racing LLC, 2311 Racing LLC from NASCAR, and Mr. Yates will hear from you.
Good morning, and may it please the court. I will focus my argument time on 3 issues. First, no court has ever held that a release of claims provision can be anti-competitive conduct in violation of Section 2 of the Sherman Act. That means, as I'll explain, that the injunction must be reversed or at the very least vacated. Second, the district court erred as a matter of law in its one-sentence conclusion regarding antitrust injury because a release does not harm competition. A release, of course, just focuses on the legal claims between the 2 parties. It has no impact on competition. Third, the district court's injunction here was a mandatory injunction and guarantees payments to teams that did not sign the 2025 charters and thereby harms NASCAR and also other racing teams. The harm to NASCAR is the injunction imposes an unwanted contractual relationship with these plaintiffs instead of allowing NASCAR to have the option of providing charters, and NASCAR provides charters for free, to teams that currently race in IndyCar or other motorsports and who want to work and come into NASCAR, race stock cars, and work collaboratively with NASCAR to grow the sport. That is what the charter system is all about at the end of the day, is working collaboratively.
Let me ask you, if we were to agree with you, what would happen from this point going forward? Because I see you've already run some big-name races, Darlington, Talladega, Martinsville. What happens, if we agree with you, what happens for the rest of this season?
If you reverse, as I urge you to do, what happens is the plaintiffs run as open teams. There are at least 4 slots in every NASCAR race for open teams. The undisputed evidence below
So would they have to qualify race by race for that?
They will, but the undisputed evidence below is they would have qualified for every race. But the whole point of the charter system, Your Honor, is to work collaboratively together to grow the sport. These plaintiffs, they were offered a contract. They rejected the contract. If Your Honors were to look at, for example, JA 67 to 69, that's 2311 in September of last year, raising 8 points that it did not agree with a contract. And then Front Row, the other plaintiff here, JA 83, says that Front Row cannot agree to the current agreement as written. We all learned in first-year contract law that these September 2024 rejections of NASCAR's offer meant there's no contractual relationship between the parties. Yet the district court's injunction orders a contract, therefore upends the status quo. And what's the harm to other teams that I mentioned earlier, Your Honor?
Well, just as a kind of a clarification question, whether we agreed with you or agreed with the other side, has trial been set in this?
Trial has been set.
And when is that?
December.
So, in theory, well, how long is it set for?
The trial is currently set, I believe, for 2 weeks, Your Honor, but there are now counterclaims, and so we need to discuss that with the district court, because the counterclaims below talk about the joint negotiations by these plaintiffs.
Yeah. So what's the likelihood that that's going to be done before the 2026 season?
The trial, I think, will be done before the 2026 season.
All right.
I think that certainly be true, unless, of course, the case gets expanded or the district court decides to move the trial date, which obviously it's within its discretion to do to manage its docket. But the point is that 2/3 of this season remains, And other racing teams would receive more money if NASCAR was not making guaranteed payments under a court-mandated contract to these plaintiffs. And so that is a real harm, not just to NASCAR, but to other racing teams. Other racing teams would receive more money if NASCAR had not been ordered into this contractual relationship with these plaintiffs. So this injunction very clearly upends the status quo. It very clearly is a mandatory injunction. But going back to the release here, it cannot be anti-competitive conduct. The district court announced what amounts to a new categorical rule that an alleged monopsonist cannot include a release of claims provision in a commercial contract, and that doing so constitutes both exclusionary conduct and antitrust injury. Everything flows from the contention that a release of claims can be anti-competitive conduct under Section 2 of the Sherman Act. The district court broke with over 125 years of Sherman Act jurisprudence in reaching that conclusion. No case in history holds that a release of claims provision violates Section 2 or can be exclusionary conduct under Section 2. That's for good reason. Releases of claims are common. They're common in commercial contracts because after negotiations are completed, the parties want to move forward with a productive relationship and extinguish potential claims between them. That was certainly true here. The teams wanted the benefit of the release that in 10.4 that NASCAR gave to the teams. They wanted that release, and NASCAR wanted to move forward with teams that had signed the new 2025 charter and who therefore had signaled a willingness to work with NASCAR to grow the sport. Those 2.5 years of negotiations, and there were 2.5 years of negotiations over this, which is a red flag that NASCAR is not a monopsonist, because monopsonists do not negotiate for 2.5 years. But it resulted in a material increase, and this is undisputed, in the amount of compensation flowing to teams. That's another signal that NASCAR is not a monopsonist. The whole theory of monopsony law is that the buyer depresses the amount it is buying and therefore depresses prices. But we've got the exact opposite occurring here. But these plaintiffs rejected the offer because they wanted even more. As I said, 2311 identified 8 points of contention and rejected NASCAR's offer. I think perhaps the district court misunderstood this context. It inherited the case about a week before it issued its injunction. But regardless, the likelihood of success finding here is based entirely on the district court's conclusion that a release of claims can constitute anti-competitive conduct under Section 2. Now, plaintiff's brief is notable in that it doesn't really even try to defend the district court's decision with respect to the release. Again, it's likely because release of claims provisions are routinely enforced. This court in the Virginia Impression Products did so. The Second Circuit did so in the VKK NFL case. Now, the district court here relied on cases that talk about prospective future releases and consider whether or not to invalidate them as a matter of contract law or public policy. Those cases are entirely different. Those cases are about whether the contract can be enforced, the terms of the contract can be enforced.
I'm not sure the release purports to release future claims. I thought the release in this case is a standard release, releasing existing claims.
That's exactly what it is, Judge Niemeyer. It's a standard release, and they were not bound by it if they didn't sign the contract. They were also not bound by the exclusivity provision if they didn't sign the contract. But the key point is this is just a standard retrospective release of claims that happens all the time when people enter into commercial relationships. This court should not be the first appellate court or even the first court other than the district court below to contend or conclude that a release of claims provision can violate Section 2. Now, the lone case that the plaintiffs cite in their brief to try to defend the district court's decision on the release is the Total Vision case from the Central District of California. Now, that case does not actually support them. That case involves a contention that an alleged monopolist had a release that was part and parcel of an antitrust violation. And the district court there, what did it do? It said we can't decide on a motion to dismiss whether or not we can enforce that release. That's a matter of contract, and it's a matter of policy. Notably, the district court in that case, I'm sure Your Honor and your honors and your clerks will look at it, what does that case go on to do? That case, after saying I can't decide whether or not on a motion to dismiss to enforce or invalidate the release, it goes on and says, let's actually analyze all the allegations the plaintiffs have made in that case about alleged exclusionary acts. Why is that important? Well, not even the plaintiff in that case alleged that a release was an exclusionary act.
So I'm sure I understand your view of the release here. If, say, after the next race, the plaintiffs were due X, whatever that is, and NASCAR paid them X minus 10, the release would not affect their rights to recover in that circumstance.
Well, I'll say it's a retrospective release. Your Honor's hypothetical is challenging because we have a situation where the plaintiffs have been given the benefits of a contract that they rejected. And so, in our view, they shouldn't get any of that. And the district court expressly said that it would consider in the future, if its injunction was reversed, how to address those kind of monetary flows. So I would say that the release itself is retrospective. What flows from the district court's erroneously, in our view, issued injunction, I think is a different question, Your Honor. I hope I answered your question there, but that's...
Well, not exactly, but I mean, if it's retrospective, I would not think that some future act would be barred by it.
I would agree. I agree with you 100% on that, Your Honor. What I'm saying is that the plaintiffs have received money,
right? I know
tens of millions of dollars.
You all think they shouldn't get any of that. I understand that.
Yeah, thank you.
The releases, they were mutual releases too, right?
Exactly, Your Honor.
So each side would be releasing the other if you get into the contract.
Exactly. This is what happens every day in the United States.
Now, if they think I gather your position is if they think the release is anti-competitive in some fashion, they either decide to enter the contract and give up that right, which is a right to sue, or they can refuse to enter the contract and sue you in the antitrust laws. But your argument is they can't have their cake and eat it too. The Omega problem?
That's definitely right. There is definitely an Omega problem here. This court's decision in Omega clearly applies because you can't ask to be bound to something you're simultaneously contending violates the antitrust laws. In fact, I think their damages case in December will rely on alleged lower payments, including in this Cup Series season, but they wouldn't have been entitled to those payments but for the district court's order. But I think the key point here is the release is retrospective. No court in history has ever said that a release can constitute anti-competitive conduct. The antitrust laws are all about protecting competition at the end of the day. This court's decision, obviously, and it's my party, talks about whether there's been an exercise of market power to foreclose competition. I think, Judge Niemeyer, you were on that decision. But a release can't have an effect on competition. It only impacts things between the parties. It has no impact on price or output. Here, if the plaintiffs don't like the deal, they don't need to enter into that contractual relationship with NASCAR. But if you want to enter into a contractual relationship with NASCAR, there are various terms that you have to agree to. But what's really important here is that in over 2.5 years of negotiations, these plaintiffs never once raised the release. They never said there's a problem with a release in Section 10.3.
Well, that's a little beside the point because the district court relied exclusively on the release to justify its preliminary injunction and allowed them to participate in the contract, but modified it by saying the release doesn't apply.
But They'd rejected the contracts, Your Honor, in September of 2024.
Well, then if they rejected the contracts, they shouldn't enter into them. But my point is that what's before us is a interlocutory appeal on a very narrow issue, a preliminary injunction, and I don't think we should be deciding what grounds would justify preliminary injunction. I think we have to take the district court where the court is and decide whether it was justified.
I agree with you, and the sole basis for the preliminary injunction is including a release of claims provision, which, as Your Honor correctly noted, is part of a reciprocal release of claims in a commercial contract. No court has ever said that is exclusionary conduct, but that's what the district court did here. It said it's both exclusionary conduct and also constitutes antitrust injury. And the district court just misapprehended both exclusionary conduct and antitrust injury. And I see my time is up.
Okay, thank you, Mr. Yates. Mr. Kessler?
Good morning, Your Honors. I will focus on this exclusionary conduct issue with regard to the release. My friend made some statements that are not consistent with the record here. And it's very important because there is no disagreement here about the legal standard that the judge below applied with respect to determining what is exclusionary conduct. He applied this court's rulings in Duke Energy, which is the most recent statement of that, as interpreting the Supreme Court authority. So there's no legal dispute. This is a factual dispute.
Well, just a minute. I'm not sure about that. I had thought coming in, and you can correct me, I had thought coming in that the district court concluded that the release was anti-competitive, and therefore, in order to preserve your antitrust claims, so the court wanted you to be able to race, but without a contract that included the release. And my concern, and I'll just lay it out there, is I don't understand the Section 2 analysis. I mean, what we need to have is the exercise of monopoly power to exclude competition. I can't see why a release addresses competition in any sense if you enter in the contract. If you don't want the contract, you don't enter into it and you sue. Or if you want the contract, you enter into it and you've given up past releases. But I think our Omega observation is you can't have your cake and eat it too.
Your Honor, you asked three different things. Let me
I
try
asked
to
a lot of
answer.
questions. You
Let
can
me
speak
answer
as
all
long
three.
as
Let me
your
try to
time
answer all
is
three.
available. Sure.
First, on whether they could have just not taken the contract. We have an uncontested finding, so it's not before Your Honor, that the district court found we would suffer severe irreparable harm.
Stay away from the harm. Stay away from all that.
Right.
Go to the antitrust theory.
Okay, I'll go right.
That's my biggest problem is the likelihood of success. I have not been able to construct a Section 2 claim based on the inclusion of a mutual releases. These are mutual releases. There's the first paragraph is your release, and the next paragraph is their release. And so the question is the inclusion of mutual releases in a contract anti-competitive in the sense that a monopolist can't include it in their contracts?
So the issue, Your Honor, if I may, is has the release been used to help maintain the monopoly position? Because
okay, let's say it is. Let's say it is.
Yes.
Then you don't enter into it.
Okay.
But you don't sit there and say, I want in under that contract and say, but I want it modified to allow me to bring my antitrust claim. Right. If you think the release excludes you from the race, from the opportunity, it's a very, very difficult antitrust theory that you have. And I've been trying to figure it out. I think this whole area, NFL and baseball leagues, is you try to figure out what is the relevant market and what is the anti-competitive conduct, because competition inherently is regulated in a context where you have a league with competing teams with a sport. Now, they clearly regulate all the rules, the size of the engines or the size of the baseball bat or whatever. But the question here is, you want in the league, but you don't want to sign the mutual releases. And the question is, the mutual releases would get rid of pre-existing antitrust claims. So if you have pre-existing antitrust claims, you should bring them and don't expect to get the contract. Or if you want the contract, then you ought to expect to get rid of the pre-existing antitrust claims. But I don't see how you can say, I want in and have the contract modified to eliminate the mutual releases.
So the difference, Your Honor, I believe in this case on these facts is as follows. Because they have a monopsony which controls the ability of our teams to compete. There's no other place to compete, which is similar to the NCAA Alston case, where the college athletes had no other place to compete in college sports. That was it. When you control the whole access on a monopsony, to maintain your monopoly, assuming it was used to help maintain the monopoly, by saying the only way you can compete is to give up your ability to file antitrust claims to challenge the monopoly.
You don't give up antitrust. You can bring those antitrust claims, but that doesn't mean you get in. In other words, the relief you're getting is to get in, and you have to be successful on your underlying antitrust claim. But in this case, they're letting you in under the preliminary injunction and modifying the mutual releases. And I haven't seen why that is anti-competitive. What it is, it's anti-lawsuit, but you can preserve your lawsuit by not entering the contract.
So, Your Honor, if we assume and we put in expert testimony, which was uncontested by them on this issue, that the release was anti-competitive to maintain the monopoly and protect the exclusionary conduct.
That's a formula. How is it? You release something, it's not anti-competitive.
It is, Your Honor, if it serves to keep out the most likely plaintiffs who would challenge a monopoly. What you need, Your Honor, this is important, they need some offsetting pro-competitive effects.
If you sign the release, you'd be in there racing. Now, what's the problem? You have the relief you wanted, which is to race, and they would not exclude you. The only reason the court is excluding you is because you refused to sign the release.
But the position they've taken, and this is important, even though my friend says now it's retrospective, their position in this case is because all the exclusionary conduct has already started and is continuing, they have taken the position the release precludes both the claims up until now and the claims going forward for the continuing exclusionary conduct in a monopoly.
Well, do you have any legal authority to support your position? Because opposing counsel says that in the 125 years of the Sherman Act, nothing supports what was done here.
So the precise question as to whether or not a monopolist may use a release to may help maintain its conduct has not been approached either way. So it's not like there's a case one way or the other. So what do we look to?
So no, so this would be the first time so he's right about that.
It's the first time the issue has come up in the context of a monopolization claim of maintenance. However, the guidance
That just seems to be, I mean, you've had who knows how many contracts over time. And I did a lot of contracts, and they had an awful lot of releases in them. And it's just hard to see that in all the history of contract law, particularly when you bring in antitrust, that this is just an issue that's never come up. And maybe the reason for that is because a release in and of itself is not I mean, you may be able to show at trial that it's part of an anti-competitive process, but I mean, it just seems like a big hill to climb if you don't have a case that supports you.
So, Your Honor, the reason I think it's never come up is, one, as Your Honor may know, there are very few adjudicated monopolization cases at all. There are a handful in the Supreme Court, there are a handful in the Court of Appeals, and it has never come up that this particular conduct is there. But what do we know? We know in Mitsubishi Motors that the Supreme Court ruled that using a release to protect antitrust behavior would be against public policy. We know that.
Well, let me ride with you. I understand your position. Your position is you have legitimate antitrust claims because apparently your argument is you were excluded from this racing. I don't know what other grounds you're relying on, but if you sign the contract with the mutual releases and give up those antitrust claims, you end up achieving exactly what you wanted, which is to be racing, participating in the racing. Now, what you want is you want to have the success of your antitrust claim preserved, and which would, the object of the antitrust claim would be to get in to be a member of the racing series. Whereas if you sign the contract, you would be. Now, the release of prior conduct is just a peacemaking device. Mutual releases, they sue each other because they're in a contractual relationship. But if you didn't like it, not for non-competitive reasons, you wanted to preserve your antitrust claim, which doesn't make sense if you're going to get in by signing. But if you want to preserve your antitrust claim, you don't sign the contract. But then you don't sign the contract, you rely on your antitrust claim to get in the league, not by contract.
So
but the idea of including a release in a contract and call it anti-competitive, I don't see it even addresses competition. What it addresses is your antitrust claim.
So, yes, Your Honor, but a monopolist preventing the most likely plaintiffs who will suffer the injury from bringing claims to challenge the monopoly.
They won't suffer the injury if they sign the contract and enter the competition.
If they sign the contract, they can't bring the claims and the monopoly is protected. That's the problem.
Why do they want to bring the claims? Because their original antitrust claim was to get into race.
No, Your Honor. So let me correct that, please, if I can. The claim was that NASCAR engaged in a series of exclusionary conduct, restrictions on racetracks so no competitor could be formed, restrictions on us that we couldn't go to competitive races.
What did you want under your antitrust claim? Set aside the releases in the
Yes.
contract. What relief did you want?
Okay. We want to get an injunction against all of these exclusions.
What relief do you want for your racing team? You want to be racing in that series, right?
We could have done that, Your Honor, under their terms already. That was not the object of this release.
You want to be a policeman? Is that what you want to do?
No, Your Honor. So this is a monopsony case, and think of it like as a consumer monopoly.
I understand what it is.
Okay, Your Honor, let's say we had an Apple monopoly, and they use exclusionary conduct to get a monopoly of apples. Then they charge higher prices for apples, so consumers sue because they're paying too high a price, and to get an injunction to stop them from excluding other apple farms from coming in and providing competition. In a monopsony case, we are selling our services, it's the reverse of the monopoly, to NASCAR, who has the monopsony. They set below competitive market prices to buy our services, just like in the NCAA, set no compensation for the college athlete. So the injury is you're getting too little. The relief that we want is to get damages for paying.
Don't sign the contract. Don't sign the contract and sue and get your relief. But to claim that you're entitled to the contract without the release is really an Omega problem.
But Your Honor, I'll come to Omega in a second, but the problem with that is that you let the irreparable harm that's uncontested, because that's what was found, they didn't contest it, that it was found it is not economically viable to have to qualify each week. As Judge Agee raised, you may not get in, you lose your sponsors, you lose your drivers. It's in the record that our drivers have contracts. If we are not chartered teams, they can abandon us and go to different teams. So,
Well,
what
all
they've
this-
done,
I think I can see all this at trial. It'd be a very interesting trial, yet to happen. But the only thing we're here on today is the preliminary injunction. And the only basis that the district court ruled on for success on the merits was a release. So it seems like to me, it's the release and the release only that's determinative for today's purposes.
so the reason, Your Honor, I would say is that if the court didn't find the release alone was adequate, I do believe that since you could affirm on any grounds, you could look at all the evidence of the other exclusionary conduct, which is really classic monopolization behavior. And
That would make us a rule on the preliminary injunction. That is something for the district court to do, but the preliminary injunction here was not based on the likelihood of that success. It was based on the fact that this contract had a release in it. And the court mandated the signing of the contract without the effective enforcement of the release.
Your Honors, I believe, have the full authority, if it's your discretion, to sustain the preliminary injunction on any ground. The evidence is all in the record. It could be done. The problem is if you reverse on this ground, and now we say, okay, we want you to rule on the other exclusionary conduct. We are, as Judge Agee noted, halfway through the season. We may lose our drivers in the interim. We may lose our sponsors. All this irreparable harm may come with the trial on December 1st. It would seem to me that if Your Honors believe that the other exclusionary conduct, and under Duke you would look at the whole thing together, would clearly justify this, even though the district court didn't specifically find that, you certainly have the power to say there's a sufficient likelihood of success on that basis.
Have you seen any case where a court of appeals is given a preliminary injunction entered on one ground, and it goes down and makes findings of fact and conclusions of law with respect to the record that was not relied on by the district court?
So, Your Honor,
We don't do that on preliminary injunction
Okay,
review.
Your Honor, I cannot cite a particular case right now. I can tell you I've been involved in a number of cases, though, where the courts of appeals have sustained rulings below on different grounds than the court below ruled upon, because they had been raised below. We raised all this other exclusionary conduct below, so it's all in the record, so it's quite proper for you to do so. But again, I understand that's something you'd have to decide.
How are we going to resolve the disputed facts, and where are we going to find the facts?
The facts are all in the record. They're really all one-sided. If you look at the declaration of Dr. Rasher, which is in the record in the first preliminary injunction, he went through each of the exclusionary conduct, the restrictions on racetracks so they can't have competing events, the restrictions on our clients and other cars that we can't go in competing events even though we're independent contractors.
Yeah, but
This
the
is not like
the district court never made any findings of fact on any of those issues. I mean, you may prevail on all of them, I don't know, but for today's purposes, we have nothing from the district court on any of those items.
That is correct, Your Honor. The court did not make findings of fact on those specific items. But what I was going to say, the expert who testified against those, Dr. Hubbard, only thought about relevant market and those issues and did not go through and offer anything on pro-competitive justification. So if there was an equal record where they put in an expert who said, here's the pro-competitive justifications, and then you say, well, someone has to weigh that, I could see how it'd be very difficult to go back now and do that, but it's a totally one-sided record. Our economists put in all the anti-competitive effects in the relevant market, and their economist said he disagrees with the relevant market, and he also put in something about racetracks as to why he thought there may be more racetracks available. That's the sum and substance of what the record was on that.
If you're right and you carry the day on some of these issues, and I suggest that those issues do sound like legitimate antitrust types of claims, because a monopolist has to be careful of how to exercise his power so as not to restrain competition. It can do it with its own handiwork, its own good practices, but to leverage its power to restrain conduct which would be competition is a problem, would be a problem. If you proved all that and come before us, then the standard will be, you'll have a wonderful position, because the fact-finding will be, clear error and all the other business and the legal theories. But we're presented with a very difficult situation where we have this very narrow preliminary injunction which inherently has some unappetizing aspects about it, and the fact that they mandate the signing of a contract, but yet they modify the contract. And I don't know if that's something that falls within the anti-competitive conduct, or whether it even falls into any, you remember our decision in Omega, we sort of said you can't have your cake and eat it too, and that's what I'm wondering whether you're asking about. Maybe not, but.
Let me at least address the Omega. I don't think Omega applies,
Yeah.
because at Omega, they were seeking to invalidate a contract and said, oh, we want the contract. Here, the relief we're seeking is not to invalidate charter agreements. We say this specific clause and one other clause is
It goes beyond that. The court mandated the signing of the charter agreement, and you have the benefit of it without the enforcement of mutual releases.
But the court also subjected us to all the other burdens of the contract, which we've been following. Other than the release, it was exactly the contract that had been offered to us. The release was the only one. He tried to make it very
I
narrow.
understand.
The other thing I just asked Your Honor to consider, the record shows that when we tried to get the transfer of the teams, that's another issue here. We purchased teams from the Stewart-Haas. They were conditioning the purchase of those teams on agreeing to this release. We specifically asked them, we said, we don't want to release our claims on the purchase. They had no justification for that, and they said, no, you can't get the teams, just as just an approval for money. And if Your Honor reverses this, they're going to take the position we should have to unwind those purchases, which is also going to be a harm to
And if
the...
they're wrong on that, they're exposed themselves to treble damages.
Correct,
And there may
correct.
be a lot of damages, right?
Correct, Your Honor, but that is another example where by overturning this now in the middle of the season and the purchases is going to cause all this undisputed irreparable harm to us, to third parties, to Stewart-Haas, who sold us. Stewart-Haas, by the way, no longer has any operation to run a team. So if we gave him the teams back, he has no drivers, he has no pit crew, he has nothing in the middle of the NASCAR season. It will cause havoc to overturn this injunction in the middle of this season. While if it just stays into effect till November, we're done. And then we have a trial, and either we win or we lose.
I have one question.
Yeah, we have one.
This doesn't go to the merits, but I was curious as to whether the parties had attempted mediation in this case.
The court ordered mediation. We have a mediator assigned. We have not yet started the mediation process, but there will be a mediation process.
Okay, thank you.
Don't you think this would be a wonderful case for mediation? Both sides have major issues, and if the parties recognize a little bit of give and take, it looks to me like it's something that could be worked out. But
Your Honor, I'm in favor of
Okay,
a
good.
settlement. Anytime you can make a settlement for both sides, I'm in favor of it.
okay, thank you.
Thank you, Your
All
Honor.
right, Mr. Yates.
Thank you, Your Honor. Just a few points. It's
I
clear
would like-
after,
At some point, I would like for you to address the argument by opposing counsel. If we decided that you were correct on the release argument, opposing counsel urges us to look at a list of other items. And so I'd like to know what you think about that.
sure, let me start with the district court's order, which is very clear that the district court emphasizes that it does not reach and expresses no opinion as to plaintiffs' likelihood of success on their other Sherman Act claims. So that's JA 177. With respect to my friend, Mr. Kessler, what he is challenging, for example, 6.6, the goodwill provision, is a standard provision and presumptively pro-competitive under the antitrust laws. Why? Your Honor, Judge Niemeyer was talking about leagues and letting people into sports leagues. What that provision says is if you want to race in NASCAR, you have to race exclusively in NASCAR to get all the benefits of the charter. If you don't want to be bound by 6.6, you can race as an open team. So we very much dispute, and there is ample evidence disputing what Mr. Kessler says in the record, and this court obviously should not be reaching out to affirm on issues that the district court did not reach. But what's clear from Mr. Kessler's argument is that the district court erred. He could not identify a single case in which any court in the United States in the 125 years of the Sherman Act has ever said that a release, a common thing, as Judge Niemeyer said in many, or in Judge Agee as well, in many commercial contracts, no court has said that a release constitutes anti-competitive conduct or antitrust injury. The reality here is that NASCAR and the teams are being hurt every day. Every day this injunction stays in place, NASCAR and other teams are being hurt. NASCAR is being hurt because it's forced into a contractual relationship with a counterparty that it doesn't want to be in a long-term contractual relationship with. Other teams are being hurt because, but for the injunction, other teams would have gotten more money. Other charter holders would have gotten more money. They would have gotten a bigger part of the pie, of the charter pie.
Do you know in the races that have occurred so far this year under the contract, are the open spots filled in most of those races? Do you know?
It depends on the race. Definitely the Daytona 500, which has occurred, the open spots are filled. In other races, sometimes they are, sometimes they are not. Now, I will say that I think that these plaintiffs' cars would have qualified for every race, even as open teams. But the point is that other teams that sign charters and are in a long-term contractual relationship with NASCAR would be getting more money, but for the district court's injunction. 2/3 of the season is left. We would urge this court to act quickly because NASCAR and other teams are being hurt. What this case is, at the end of the day, it runs straight into Omega. I agree with Judge Niemeyer on that. They are trying to have their cake and eat it too. They found 10.3. 10.3 was their ability to try to get an injunction mandating a contract that they'd rejected. Again, they rejected terms. They don't like the terms. And yet they asked the district court to order an injunction. We cited cases like the Host case from the Third Circuit and this court's Lauren Data case.
I gathered they would try to enforce 10.4 against you with respect to claims.
If potentially, I mean, they have not said they would not, and so we have counterclaims, and so we're now in a position where potentially they would argue in the district court, improperly in my view, that the release in 10.4 covers our counterclaims. So this is another problem with mandating a contractual relationship. At the end of the day, that's what this is. The district court erred by imposing a contractual relationship, and again, they rejected the contract in September. The litigation didn't start until October. But the Host case and the Lauren Data case from this court say there's no antitrust injury if you don't like the terms of a commercial contract, you don't sign it. That's what happens. Those cases both say that just because you don't like the contract terms that are offered doesn't mean that there's a violation of the antitrust laws.
All right.
We ask this court to
If I
reverse.
can add one thing, is unsolicited observation from where I sit. I would hope the parties would take mediation seriously.
Certainly, but we're not going to rewrite the charter contract. I mean, the charter contract exists, and that's what they really want at the end of the day. They don't like the terms. They call all the terms, they call them all below competitive. We're not going to rewrite the charter contract, Your Honor. But certainly we're going to participate in mediation. But the clear thing here is the district court erred, as even Mr. Kessler appeared to acknowledge. Thank you.
We'll come down and greet counsel and proceed on to the next case. right, the next case we'll hear this morning is Chappelle versus Truck Pro. Whenever you're ready, Mr. Calloway, we'll hear from you.
Good morning, Your Honor, and may it please the Court. Jordan Calloway on behalf of the appellant Ernest Chappell. The key issue in this case is whether a reasonable jury could conclude that the faulty cab guard likely passed through the hands of Truck Pro on its way to reaching the logging truck driven by Christopher Chappell. The evidence shows that Truck Pro is by far the most likely distributor of this cab guard. Pictures of the cab guard itself shows exactly where it originated, with a company called Rogear, and even the precise day where it came off the assembly line, April 4th, 2008. From there, Rogear's records show that this was manufactured as part of a small, discrete batch, likely of only 12 units, 10 of which were shipped directly to Truck Pro. From there, within days of receiving them, Truck Pro then began to ship Rogear cab guards to multiple South Carolina buyers within the month, and then continued to do so over the next 3 months of that same year. The district court concluded that none of this was sufficient to get the case to a jury, but only after misinterpreting both South Carolina's substantive standard and the evidence requirements in order to show that a distributor was linked to an allegedly defective product. This court should reverse, both because of the evidence in the record and because the district court's ruling threatens to quietly rewrite South Carolina products liability law. I'd like to start with the evidence in the record that links Truck Pro to the subject cab guard. There are multiple pieces of strong...
I think we understand that. The question, I think, and it's a very interesting question, it's been subject to debate, is you have evidence that 10 units went to Truck Pro and 2 units went to another distributor, but you can't determine whether the cab guard in this case, which course it took. And even after, if it went to the other place, what was it, Mobile?
Trail Mobile.
Yeah, Trail Mobile. If it went there, you don't quite know the course it went anyway. But your supposition is that because Truck Pro got 10 as opposed to 2, it's more likely than not it is the proper defendant. And the question is, the theory is a sort of a preponderance of the evidence as to who the defendant should be in this case. And I'm not sure general tort jurisprudence has done that. I mean, if you change the numbers and you say, okay, 6 went to one distributor and 7 went to Truck Pro, you would argue still that because 7 is more than 6, preponderance of the evidence is more likely than not Truck Pro should be the defendant. But you really need some evidence to prove it was Truck Pro. Otherwise, we will be bringing defendants into litigation just based on statistics.
And Your Honor, I want to make an important point. We're not just relying on the 10 versus 2. I think the 10 versus 2 is an extraordinarily important piece of evidence here, but it's not the only one. The other evidence we have are, and there's no response to this on the other side in their brief, that we have records from Truck Pro showing sales of Rogear cab guards to South Carolina buyers within days of them receiving these 10. There are no evidence whatsoever that Trail Mobile ever sold a Rogear cab guard to a South Carolina buyer. There's no evidence whatsoever offered by Truck Pro to suggest that they're not responsible for
Actually, it's even a little more remote because the owner the owner of the truck, there was evidence that he bought used cab guards from other truckers.
But Your Honor,
and a majority of them, there's just really no evidence that you can say. Let's assume there were 51 cab guards that went to Truck Pro and 49 went to other persons. There is just no evidence to say that it was the 51 as opposed to the 49, except that 51 is a greater number than 49.
No, I disagree with that, Your Honor.
Well, I know you do.
Yeah, because I don't think it gives account for the fact that we do have this connection between Truck Pro and South Carolina, the area where this incident took place, and there is no such connection when it relates to Trail Mobile. I think that's one important piece. I think it's also very different, 51-49 versus 10 versus 2.
No, it didn't, not under your theory. Your theory relies on a preponderance of the evidence, and you kept using in your brief the word causation, which it's not a causation issue at all. It's the identification of a defendant.
Well, but I think the identification of the evidence of the defendant relates to the cause and fact element of our claim. So
Well, in a big picture, who caused your injury it is, but causation is what causes the accident, and that is always determined on a preponderance. But who the defendant is, you have to have some evidence and to link it to a particular defendant. Just because statistics show that it's a greater chance that one defendant would be more likely to be the proper defendant, it would be a strange tort system if we were allowed lawsuits just based on statistics like that.
I would make a note to Your Honor to the case of McCoyne versus Upstate Lung, where a South Carolina Court of Appeals relied on an expert opinion that said just based on the 95% probability that tumor 1 led to tumor 2 was sufficient to get past a directed
That's a
verdict.
causation issue. And your brief did this again and again. You spent almost all the time talking on what caused an injury. In other words, you have an accident, there's multiple causes often. And the question is, causation is subject to be presented to the jury, and the jury makes findings of fact of what cause. But here, we're identifying a defendant who's responsible. And the question is, can you identify a defendant who's responsible statistically? And I don't know that is an appropriate mechanism, I think, under the tort law system. But
My point is that I think what the Court of Appeals, our South Carolina Court of Appeals said in McCoyne is exactly that, is that in identifying whether this defendant caused this injury, that the fact that an expert said the 95% probability was sufficient to get it to a jury, that the directed verdict was improperly entered.
What if the evidence in this case was that 6 of the truck guards went to Truck Pro, but 6 went somewhere else, so it's even? How would that affect your case?
That would affect it in one way, in a couple senses. It would certainly make it less likely, right, or more probable, if I can say it that way, that Truck Pro was the one that was responsible. But it would still be a situation where we do have a connection between Truck Pro and South Carolina, where there's no connection between Trail Mobile and South Carolina.
You mean if it was in Judge Agee's hypothetical there, it was a 50-50 chance that it was a particular defendant, and you would still be going after that particular defendant based on a 50-50 chance that they were the responsible party?
If under your hypothetical there was also this difference between the connections between the two entities and the forum state like there is here. But no, if it's strictly 50-50, because that's the scenario they outline in the Ryan case, where you've got these two possible defendants, and the district court says, well, it's possible that the proper defendant is here, but it's just as likely that they're not. And that is not this case. Because in that situation, there was 25 years ago, no one could tell, it's a totally fungible product. That's not the situation here. We know exactly where this product originated. We know exactly, or we have more likely than not from the manufacturer itself, how many were in the batch, that they went to two distinct locations, 10 to one, 83% to one, and 16% to the other, and to no other place. And then we have, within days, this connection between Truck Pro and South Carolina that they're selling them to South Carolina buyers.
All right, well, at the risk of repeating some of Judge Niemeyer's questions, take it under your theory, if 5 went to Truck Pro, you would lose. If 7 went to Truck Pro, you would prevail.
I don't think it's as simple as just looking at those pure numbers, because that's not strictly what we're relying on here. We're not relying strictly on the numbers. We are able to start with the product itself and go back to the manufacturer, and the manufacturer gives us more evidence, records and testimony that links where these things then were shipped, and then we have the records from Truck Pro showing the
Right,
sales.
but if you've got all that same evidence, and only 5 went to Truck Pro in one example, and 7 went in the other example, tell me what the difference is as far as your case is concerned.
I think the 7 is stronger than the 5, but I think that that it doesn't necessarily make the ultimate difference between those two cases. As to simply the question of whether it gets to a jury, right? Just simply the question of whether
It's a question
reasonable
of holding a defendant responsible and bringing them to court. In other words, the question is, do we summons people to court for torts where the only statistics create a likelihood as opposed to any other evidence? And the question is, I'd give you even more complex. This is a fairly simple division, but what if you had 50 guards manufactured and they distributed it to 4 different distributors, none of which was a majority. So you could pick any one of them. You're talking about a plurality. This statistical business of holding people liable in court for something they may not have done simply because there's a statistical likelihood is foreign, I think, to our system.
Well, I think with the first part of your question, I'm thinking, Your Honor, goes to the concept of market share liability, and this is not a market share liability case. Market share liability is like those DES cases.
I didn't characterize this as anything. I'm talking about relying on statistics to identify defendants.
And I think that is an acceptable way of using circumstantial evidence to get a case to a jury. The way Your Honor phrased it is that you could get a case to...
So you think that based on speculation, basically, you can bring a lawsuit against a particular defendant and subject them to all that entails in defending themselves?
No, Your Honor. And
You don't have more than speculation.
I
Do you know
disagree.
for a fact that this guard was sold to the Turner Trucking?
Do we know for a fact? We know
Right.
more probably than not, but the answer, do we know for a
Did you say what,
fact?
more probably than not? Then that's speculation.
No, I disagree.
And you don't know for a fact because Mr. Turner himself said he did not remember where he got.
From whom he purchased it.
From whom he purchased.
From whom he purchased.
Right.
But that's not a requirement for us. We don't have to prove from whom he purchased it. If you look, for example, the Sizemore case, which quotes from Madden versus Cox, the South Carolina Court of Appeals case, you must only prove more likely than not that it was in the hands of the defendant at some point. So we don't have to prove a direct sale to him. And that's actually would be inconsistent with South
But it
Carolina
becomes a
statutory
market
law.
share because he says he didn't know where it was purchased, and he also said a majority of his cab guards were used from other people. They could have been from New England and from Tennessee and from Chicago. In other words, these truckers are interstate truckers probably, or sometimes, but you don't know that either. And the question is, we're just sort of going into this big murky mire of tracing a particular product through used hands and multiple hands and saying because the manufacturer shipped it at the initial stage to a particular distributor, therefore that distributor is going to be responsible.
Here's what we know from what Roe Gear testified to. There were only 12 cab guards, most likely, from his perspective based on their records, that ever had that 448 stamp. Only 12 in the world, and 10 of them went to Truck Pro. And then Truck Pro, within days of receiving that set of guards, starts selling them in South Carolina and sells them in South Carolina month after month after month. And the other 2, the one that got the other 2, there's no indication they ever sold any to South Carolina.
No, you can't draw a negative conclusion. You don't know where they went.
We don't, but we do
You
know
don't
that
know
10
where
of
they
them
went. I mean, a record is neutral on that.
But if Your Honor's point is that we have to show definitively,
I think
and
you
that's...
have to show some evidence that points to somebody as a defendant other than statistics. You know the blue bus hypothetical that all the academics do? You go down, a blue bus comes down and runs somebody off the road, and they don't know who drove the bus, they didn't stop the bus, and the blue bus company owns 80% of the buses in the city, blue buses, and somebody else owns the rest. Can you hold them liable? And all the academics say no. They say you need What it is basically statistically finding defendants as opposed to having some evidence directly against the defendant.
But I think if Your Honor were to say categorically that the statistical evidence can't be used as part of the equation, it would be inconsistent with at least two cases cited in our brief. What the court did in the Kramer case, which said ultimately they found that there were two possible providers of an airplane nut. 90% of them came from one company, 10% of it came from another company. They reversed a summary judgment ruling. In Treston, a case from a New York Court of Appeals, there was a question of who provided the vinyl lining that was used in a pool liner. There was 4 possible providers. They narrowed it down to 2. They could get 95% to one, 5% to the other. The court reversed a summary judgment motion in that case as well. And so
Thank
those
you.
are both instances.
Yeah, we'll have you back on rebuttal.
Thank you, Your Honor.
Yeah. All right, I guess Mr. Gardner?
May it please the court. Kenny Gardner on behalf of the respondent, Truck Pro. I'm going to address the issue that this court has paid most attention to in the identification of this particular product. And I think Your Honor has it correct, is that it's pure speculation. What they're doing is they're saying that because we purchased 83%, potentially 83% of a product, that we therefore sold 83% of that product to the end user. But that's not the case here. The leap is unsupported by the evidence. The manufacturer themselves say, we can't tell which one of these cab guards that were made on this date went to Truck Pro or to Trail Mobile. They have no idea. They said, all we can tell from the information that we have is the date of its manufacture. Now, there's a part number on these, for this model of cab guard, but it's not limited to the cab guards here that are stamped with the 448. That part number that Road Gear uses, and that was on the invoices sent by Truck Pro to South Carolina, is for every single one of those models, regardless of when it was manufactured. So here, they make a lot about this, oh, well, we've got evidence of them selling cab guards into South Carolina. Well, that part number doesn't distinguish whether or not
I thought the part number was a date.
No, that's the distinguishing mark on the actual cab guard. But the cab guard itself is a model, so.
Is the 44, what's the 12 he was talking about? Is that the 448? He said
Yes.
there were only 12 in the world or something.
Well, that's not the testimony. The testimony is from Road Gear that it is possible that there were more. And it was possible that they kept a stock back so that they may not have sold all of them. But again, that makes it that much more speculative here. Because that part number, although the same, and then it shows on these invoices.
On the 10 that went to Truck Pro, is there evidence in the record that all of those were sold?
No, Your Honor, there's none. There's no evidence that one of them was sold. And that's the issue here. And I think this court goes right to it, is that you gotta have more. This percentage of we purchase and not distribute is not enough. That by itself is not enough, especially when the end user, Mr. Turner, doesn't know where he got it from.
Well, your colleague said that Truck Pro distributed it to distributors in South Carolina. Is there evidence in that?
Not that it's one of these 448s, right? That, again, that goes back to that part number. So
from the records point of view, those truck guards could still be in inventory.
correct. It's completely speculative, because a jury would have to guess that one of those invoices with that part number meant that it was one of those that was a 448 stamp. And then they would have to guess that it was sold in South Carolina.
So
and then
on the invoice then, it has the part number, I mean, is this what the record show? It has the part number, but it doesn't have the date stamp of
Correct.
manufacture.
Correct.
Okay.
And again, Road Gear manufactures an innumerable amount of this model of cab guard. The distinction here is that these 12, or these alleged 12, were stamped with the manufacture date. So that part number does not narrow the field. So again,
Is this a cab guard? Is it fastened to the trailer or to the cab?
it's fastened to the cab.
To the cab, so it's bolted on the back of the cab. And I was just wondering, as I was reading this record, why trailers don't come automatically with cab guards built onto the trailer so that the load can't shift forward. putting a steel barrier there. I guess that's not so, is it?
Well, one of the reasons that Mr. Turner says he buys and uses is that they're so expensive. So presumably, excuse me, it's too expensive to add these things. I don't know the answer to that, Your Honor, but what I
Yeah,
do...
it's a curiosity, it's nothing.
But here, where Mr. Turner, who owns an interstate timber transportation business, says, I don't know where I bought this. I bought them used, and I bought them from individuals. That's the only testimony. They cite to the Kramer versus, excuse me, they cite to the Kramer versus Weedhopper case, but that case actually is in our favor. In Kramer versus Weedhopper, you had the end user who was injured, the plaintiff. There's testimony that he purchased it from Weedhopper, who was the seller. Weedhopper got its product from 2 different distributors. Those distributors got it from one manufacturer. The testimony from the store that sold that kit with that screw says, we bought 90% of our product from this distributor and 10% from the other distributor, and that the distributor that we bought 10% from was only used on prototypes. So the court said, realistically, and very rightly so, that in that situation, they showed that distributor A, more than likely, or by the preponderance, had enough evidence to identify the probable defendant in that case. Here, if we were comparing the facts, you have the manufacturer sells...
The 10% in that case then was, whatever the thing was, did not enter into retail sales. You said he was using a prototype, so it was not, the 10% was not used for retail sales to the public.
It just said, the case just said prototypes, but it also said that it would use those for special orders when they didn't have any other ones. But again, I think the point in that case is that there is evidence there that you could identify the distributor. Here, all you have is manufacturer to distributor. Huge gap, end user. And all of the cases in South Carolina, they've been dealing with this issue since 1940. And
Well, it's a tort law problem. I mean, the academics have been dealing with it too. It's not unique to any given state, I don't think.
Correct. Correct.
We're under a general system of torts. Probably restatement of torts is probably closely followed in most states.
I agree with that. And as a practical sense, you have to have those links connecting the defendant with the product. In the Gant versus Coca-Cola of Columbia case, it's much like the Kramer case. The injured party knew that he bought the bottle of Coke from a store. That store had records and had testimony and evidence that it bought its supply from this Coca-Cola distributor in Columbia. And the bottle in that case had Columbia on it. We don't have any of those links here. The gap between the end user and where they can last trace the potential sale of these things is just far too great. So the lower court was correct in ruling that there was an absence of evidence to establish that we put that Truck Pro put the cab guard into the stream of commerce, and it was accurate in saying that any determination would be purely speculative. They have to do more in order to get there. Another case that I think is on point is Holmes versus Narco, which was in the South Carolina District Court, where that court outlined ways that courts have used to identify a manufacturer or a seller. You have the chain of evidence or chain of sale. You have uniqueness of the product, you have control of the product, and then you have bill of sale, those types of things. And in that case, the court says it is the plaintiff's burden to prove that a defendant or an alleged defendant either sold, controlled, or otherwise put a product into the stream of commerce. And in that case, there was no evidence. And the court said, you cannot shift that burden onto the defendant. So when the plaintiff says, well, Truck Pro never proved that it wasn't theirs, well, it's not our burden. Our Truck Pro never proved where the Trail Mobile cab guards went. That's not Truck Pro's burden. That's the plaintiff's burden to prove. And There's nothing in the record that would establish that he is able to prove that here.
Anything else?
I think Your Honor have it all. Thank you.
We'll hear from Mr. Waring.
Thank you, Your Honors. At the risk of being redundant, I think this case really boils down to a couple of things. Probability versus possibility is one it boils down to. 83.3% is nothing but a red herring. And lastly, proof connecting the defendant, this defendant, Truck Pro, with the offending instrumentality is necessary, and it is the plaintiff's burden to do that. They have failed in that burden. The record contains no evidence that we, Truck Pro, put this particular product, the offending product, the one that injured Mr. Chappell and damaged Mr. Chappell, that came from Truck Pro. And it's just a failure of proof here, Your Honor, and I agree with you. The 83.3% is great on how many units went to Truck Pro, but it has nothing to do with whether one of those units injured Mr. Chappell. I'm happy to answer any other questions you may have.
Thank you.
Thank
Mr. Callaway?
There's a couple of important points here.
Can I ask you a question just before you get started?
Yes, sir.
There was a claim that there is no evidence that the units, the 10 units that went to Truck Pro, were ever sold. Do you agree the record doesn't show that?
Your Honor, no, that would be inconsistent with the testimony of Road Gear and how this process actually works.
No, I didn't want the process. I'm talking about these actual 10 units that were manufactured on 448. Is there evidence of where they went or whether they went anywhere?
There is an admission by Truck Pro that they're a product reseller. They don't consume
I
these
understand
things.
that. That's their business to resell. But I'm talking about, is there evidence to show those particular units? Because that's the guts of your case. You're trying to trace those units. Is there any question that those units, could there be, those units are still on the shelf at Truck Pro's inventory?
There would be that would be completely inconsistent with their business model, is what I would say.
What's the evidence? You don't have any evidence. I just need to know, is there evidence of, do you have any bills of sales, shipping documents, or anything that show that the 10 were shipped at all?
We don't have a specific tracing of one unit from the next to the other. That's true. But again, we're dealing with most probably. We're dealing with
Well, you're most probable because they're in business to sell them. But
no, but beyond that, they did then sell within days of receiving them from Road Gear cab guards to South Carolina buyers. The way this process.
Where's the evidence that the 448 units went? You're making a generalization. You're jumping from their business model to and trying to encompass these particular units.
But, Your Honor, business model evidence is important under Rule 406.
I understand, but I'm trying to ask you a question about the record, and the question is whether these particular units, there's evidence that these particular units were shipped from Truck Pro.
I think that's a reasonable inference that a jury could draw from all the evidence that is presented.
The answer is no, right?
If you're asking for do those documents specifically say they're 448, that answer is no to that. Okay. Yes, Your Honor, that's true. But again, when we're dealing with, is there a question for the jury as to who is the most probable seller of one of that 448 unit? We know where it ended up. We know where it started. We know they had 10 of them. We know they're selling them to South Carolina. We know that, or we don't have any indication that Trail Mobile has ever sold them to South Carolina. We know that it's not their business model.
You say there's no evidence that you make a big deal, there's no evidence about what happened to Trail Mobile's purchases. But yet, that's identical to your circumstance. You have no evidence that yours went to South Carolina. In other words, they could be on inventory, and the two could have gone to South Carolina from Trail Mobile.
But the question is that
on this record?
But the question is, what is more probable?
No, I didn't question. The question is, what's the evidence show?
But what could a reasonable jury, with all of the inferences are to be drawn in our favor at the summary
So
judgment
Trey
stage.
Bro comes in and says, you know, we're in the business and we sell 40% of our products in South Carolina, and we sell 30% to North Carolina, and we serve 30% in Georgia.
That'd be a very different case.
And so that would help you?
No, that would be a very different case. That would be more evidence that
That's what this record allows, because you do not have direct evidence as to where those units went.
But I think the ultimate point where I'm disagreeing with Your Honor is that your suggestion is that we have to show that all
I didn't
inferences.
say what you had to show. I'm trying to identify the evidence. If you can stick with me for a minute on
Sure.
the evidence.
Sure.
We start with the evidence in the record. And
And
the
the-
record evidence shows that Truck Pro received 10 units.
That's correct.
And after that, we don't know where they went,
We
based on tracing.
tracing, right. If Your Honor wants to turn tort
I
law
don't
into
want
basically
anything.
trying.
I'm asking what the record shows.
Right, but Your Honor, what they're basically asking the court to do is to give you a chain of sales from
Well, that's-
manufacturer.
Sure, that would be a good thing to do if you're going to hold Truck Pro in.
Right, but to require a full chain of sales from manufacturer all the way to end user is not consistent with South Carolina law. 1573-10, Section 2B says we can hold a defendant
But
liable
you
for.
don't have any chain of sale. You're saying we're trying to hold you to a full chain of sale. You don't have any as far as I can see.
But what we do have is evidence that there is a distinct marking on this device, that there's only 12 of them, that 10 of them went to this defendant, and that this defendant is selling them to South Carolina, and there's no evidence that the other defendant was
Well, there's
selling.
no
or the other-
evidence that they sold them in South Carolina. That's a leap. You say that's their business model.
I think that's a reasonable inference from the evidence that is
I
the
don't know why they didn't sell them in North Carolina.
But again, reasonable inference, Your Honor. Do we have to prove it absolutely to get to a jury? That's the
That's all
question.
right. Okay, I understand. All right, we'll come down and greet counsel and proceed on to it. Okay, and we'll take a short recess and after we greet counsel.
This honorable court will take a brief recess.
Virginia versus Hunt, and Mr. Podol.
Good morning, Your Honor, and may it please the court, Josh Podol of Williams and Connolly for Caremark. Pharmacy benefit managers, like my client Caremark, negotiate the net cost of drugs for their health plan clients with manufacturers. Now, some of those clients are private insurers. Others administer health plans for the federal government under the Federal Employee Health Benefits Act, or FEBA. To maximize its leverage in rebate negotiations, Caremark negotiates the net costs of drugs for multiple plans at the same time. Those negotiations are not separated into FEBA and non-FEBA buckets. During the relevant period, all insulin rebate negotiations Caremark conducted for FEBA plans were for non-FEBA plans too. That means the rebate negotiations that West Virginia characterizes as a deceptive scheme and challenges in this case are in fact the very negotiations that determine how much the federal government ultimately will pay for medicine federal employees receive under federally sponsored health plans. Considering these exact same facts, the First Circuit held in the Puerto Rico case that federal officer removal was proper. That decision is indistinguishable and it is correct. The court should reach the same conclusion here. First, this court and others have consistently held that contractors and subcontractors act under federal officers when they help implement federal health care programs. And that's just what Caremark is doing when it negotiates rebates for FEBA plans. It works to drive down the net drug costs so that the government can offer competitive health insurance benefits to its employees. Second, Caremark's rebate negotiations for FEBA plans are connected or associated with
So is there any distinction between this case and the Puerto Rico case from the First Circuit and the California case from the Ninth Circuit?
There's not, Your Honor. It's the same set of allegations. I suspect what my friend Mr. Magistro will say is that in this case, the only recovery sought is by the West Virginia state plan, but that doesn't matter to the allegations underlying our notice of removal, and West Virginia attacks generally rebate negotiations in the scheme, and if you look at JA 129, they seek recovery for, they say, and I'm quoting, the PBM defendants' negotiations have caused and continue to cause precipitous price increases. So it's the same challenge to price increases coming out of negotiations with manufacturers. Those negotiations are indivisible. And so in other words, the state's challenge to the rebate negotiations and the prices that the manufacturers set after them, both here and in Puerto Rico and in California, is necessarily a challenge to Caremark's FEBA negotiations, and any attempt to isolate the impact of non-FEBA plans would raise exactly the kind of difficult causation question that Your Honor said in 3M has to be decided in a federal forum. As to the last element of federal officer removal, which is the colorable federal defense, Caremark has two more than colorable federal preemption defenses, though all they have to be is colorable. First, FEBA has an express preemption provision that would bar the state suit in its entirety, and even if it didn't, there's an obstacle preemption defense here because what the plaintiffs are doing here and in all of these insulin cases is making a broadside attack on PBM's rebate negotiations with manufacturers, which are a core element of their business model, and of course, a core element of the healthcare system, the way that drug prices stay reasonable and the way that the federal government under FEBA is able to offer competitive prices is having pharmacy benefit managers like Caremark and others negotiate rebates that drive their net cost down. So there's an obstacle preemption defense in that a ruling for the plaintiffs here would fundamentally disrupt FEBA and undermine its core goals. For all those reasons, and as discussed further in our brief, the court should reverse, and I welcome the court's questions.
Okay. Is that it?
That's all I have prepared, Your Honor.
I have one question. Can you talk about the recent, the Hawaii opinion that you filed the supplemental?
Yeah, absolutely, Judge Thacker. So 3 points as to Hawaii. The first point is Hawaii fundamentally has nothing to do with this case because the district court, it is the same facts. Or actually, it's similar. The plaintiffs there pleaded, although the allegations look similar, they pleaded something slightly broader to avoid going into the federal MDL, but it's the same general allegations. However, the Hawaii District Court started by saying that First Circuit and Fourth Circuit law, Puerto Rico and then 3M, are distinguishable. And then it proceeded to apply, at least to the causal nexus standard, what it conceived as Ninth Circuit law. Now, we disagree with that ruling of Ninth Circuit law, but so for that reason, it's distinguishable.
So it, like the First Circuit and Ninth Circuit cases you talked about earlier, has similar facts, but you disagree with the application of the law.
Correct, and I can get to that in a minute, but there's actually, the more fundamental point is the court itself said that it believed Ninth Circuit law was different. So it didn't try to apply, it didn't try to disagree with Puerto Rico, it just said the law in the Ninth Circuit is different and imposes a higher threshold. Second, its holding on the causal nexus requirement essentially was that there wasn't evidence that the government directed Caremark to conduct its rebate negotiations for FEBA and non-FEBA plans at the same time. That holding runs headlong into this court's decision, Judge Niemeyer's decision in Sawyer. It also runs headlong into the Supreme Court's decision in Acker, which says that the federal government doesn't need to prescribe every detail of how conduct is done. As far as I know, every circuit to consider the question has said the same thing. The Second Circuit in Isaacson, Third Circuit in Ray Commonwealth, Your Honor, in Sawyer, the Fifth Circuit in a number of cases, the first in more. And then finally, as to the disclaimer, the court credited Hawaii's disclaimer, but it did so based not on allegations about the price of insulin, but instead based on the fact that FEBA and non-FEBA plans are administered separately. That is a completely separate question than the effect on price.
Thank you.
If there's nothing further, I'll save any time for rebuttal.
Yeah, thank you. You have for rebuttal.
Thank you.
Mr. Machestro.
Thank you, Judge Niemeyer. May it please the court. My name is Anthony Magestro from Powell Magestro and Charleston, West Virginia, and I represent the state of West Virginia and its health plan. I think it's important to start out explaining what the claims, the limited nature of the claims in this case. There's no allegation in this case that the plaintiff is seeking to recover expenses paid by health benefit plans from anybody else other than the taxpayers and the insurers of the state of West Virginia. All of the other cases that are at issue here are governmental entities bringing broad consumer protection claims on behalf of groups of people that are much broader than the state is bringing here. And why is that important? That's important because the state of West Virginia has a separate contract with Caremark, or did at times relevant in this case. Under that contract, Caremark promised to pay, and this is a separate contract not negotiated with the federal government. Now, the contract between Caremark and the drug manufacturers, they allege, and we haven't had a chance to do any discovery, but that was one unitary negotiation. But there was a separate contract.
For removal purposes, don't we have to credit?
And I think under this court's recent decision in 3M, your decision, Judge Agee, I think that's correct.
Well, didn't the First Circuit and Ninth Circuit do the same thing?
I think the First Circuit did. But the Ninth Circuit, what they did is they remanded for jurisdictional discovery. And since the Ninth Circuit remanded,
Well,
every...
Judge Ito agreed with the First Circuit.
He did, he decided. But since the Ninth Circuit remanded, every Ninth Circuit district court in these cases has remanded the cases to state court. Hawaii reversed itself, Nevada remanded, and Los Angeles, the court in Los Angeles remanded. So the application of the Ninth Circuit test, when you actually get down to look at the facts, in the disclaimers, the courts they're remanded.
But for you to prevail, we would have to say the First Circuit and Judge Ito were both wrong.
Yes.
Okay.
But I think there's another way we're going to. And what I would like the opportunity, and let me finish the point I was making before, and that is the separate contract for rebates is apart from the contract for the drug purchases. And so if you credit their theory that they created this great deal with the defendant, with the manufacturers, where they got rebates, what they did with the rebates differs by contract with the different plans. And the law applicable to those
You
contracts.
agree that those negotiations, though, were collective negotiations for the entire purchase of the drugs?
Okay,
And your argument is that after they obtained the rebates, then they handled them differently with respect to the different customers?
And that is the nature of the plaintiff's claim in this case, is that it was their obligation to return those rebates to the state of West Virginia. That was what they were hired to do, as my friend said, to lower the net cost of the drugs. And the contract the state of West Virginia entered into with Caremark was for them to return all of those rebates to the state. The allegation in the complaint is that they did not. There's no federal interest implicated by holding them to the breach of that contract. And that's simply our claim. Now, I recognize that since we filed this case, since Judge Bailey ruled on it, since we briefed it, there have been a lot of decisions. And one of the things that I was struck by, Judge Agee, was what you did in 3M. In 3M, after the court following the Raoul case in the Seventh Circuit, 3M was an environmental case for Judge Niemeyer and Judge Sacker, where the question was, what was the source of the pollution? So a federal source and a non-federal source. And there were two cases, 3M, and then there was the Raoul case in the Seventh Circuit. In Raoul, what the plaintiff did was the plaintiff agreed that if any of the pollution came from the federal source, they lost. That solved the problem that my friends bring up, that they're supposedly entitled to a federal court determining that causation. We disagree with that, but we acknowledge that's what 3M says. But if the...
Well, in some ways, this would seem to be an easier case, because in 3M, you had this situation where there could be some that were attached to federal property, some that were not. But here, you have, it would seem like a unitary situation, because you've only got a single negotiation. So this actually seems to be an easier case than 3M.
Easier case for me or for them?
For them.
Okay, and I'll tell you where after reading all these decisions and why I brought up 3M and Raoul is because in 3M, this court gave the state the opportunity to disclaim all of the federal. And after reading the decisions and discussing it with my client, the state is willing to do that here. The state is willing to say that the price negotiations, the unitary price negotiations, to the extent that our complaint alleges that Caremark allowed the negotiations increase the price, and that claim, I concede that claim's in the complaint. We're willing to waive that claim against Caremark and limit our claim only to...
Aren't we supposed to take the complaint as filed on a jurisdictional basis question?
Those statements appear in the law. In these cases, that hasn't happened. In 3M, you had that offer to the state. In Raoul, the Seventh Circuit made that offer to the state. In California, Ninth Circuit opinion, they remanded for clarification of the waiver, and in the Hawaii case, they did the same. They allowed jurisdictional discovery. So I would go back to this idea of federal jurisdiction. Federal courts are courts of limited jurisdiction, that there needs to be some limit, and what the courts appear to be doing is that they appear to be being very careful about when we let private parties take advantage of federal defenses. And generally, the rule is that federal defenses are not things that give us jurisdiction. And so by the state agreeing to waive any claim with respect to insulin price and limit their claim against Caremark only to rebates, to the separate contract that has no federal interest, separately negotiated, there is no difficult, as this court said in 3M, difficult causation questions to be handled by the state court. The state court looks and sees what rebates Caremark got.
None of that was before the district court.
And-
It's not in the record.
And nor was it in the record in 3M when you made that offer, nor was it in the record in Raoul. And you know, I would suggest that maybe remand to allow those stipulations to happen would be appropriate. The state's willing to do that.
Thank you. Mr. Vidal?
So,
You heard it for the first time here. What do you say here?
I did, Your Honor. I say that I don't, I think as with many things, the devil's in the details, and I don't think the state is actually going to be willing to give up what my friend just said, because if it were, it
Well,
would be giving
he
up.
just said it pretty clearly, and my question arises, and I understand this is unusual because it's not in the record and it's not in the complaint. My question is whether this would be an appropriate question on remand, that if it wasn't waived, we could have one ruling. If it were waived, we could have another ruling. I don't know if that's possible. Or they may be the same ruling, but clearly the state wants to litigate this in its own courts and is willing to go some lengths for that purpose.
The problem, Your Honor, is what this is. This, in the complaint that we have in front of us, and in the complaint that the court has in front of it, is a, quote, insulin pricing scheme, which consists of negotiations between pharmacy benefit managers and manufacturers to raise the price of insulin. That is the core fundamental allegation in the complaint. The core allegation in this complaint is not, Caremark, you should have returned $10 and you actually gave us $5. That would be a harder case. But the allegation in this complaint is you engaged in improper conduct that inflated the price of insulin. So I appreciate what my friend is saying, but I think on the complaint that's before the court, on the record that's before the court, unless they are almost literally waiving everything except what I said, any claim that we were unjustly enriched, any fraud claim, anything of that nature, still has all the same problems. So with all respect, one, I don't think you could have a waiver here to the extent rebate negotiations, as opposed to just literally the payment is challenged. I don't think you could have a waiver that would work. Two, I think the proper course here, to the extent the state wants to make such a waiver, is for the court to go ahead and rule on this case, and the court should do the same thing the First Circuit did in Puerto Rico, reverse the remand decision. The case will be sent to the multi-district case in front of Judge Martinotti. And if the state wants to amend there, then it can do so, and we can have a solid record to address this on. Because it could be, if counsel really writes a complaint that just says, Caremark, you breached your contract because you should have given us X dollars in rebates, and you gave us Y, not because the prices were inflated, but just because you gave us the wrong amount of money, it'd be a hard argument for me, I would concede. But that isn't really the flavor of this complaint, or in this complaint at all.
Clearly not.
And so,
And he concedes.
and I think it would be perilous, I think it would be fraud and lead to confusion to take the approach of essentially rewriting the complaint on the fly. I think the court should rule on the record that's in front of it. I think we should go ahead and proceed, and then if the state wants to amend to address these issues in a way that will truly take federal conduct out, then I think it could do so. But I don't think that doing so now is either legally proper or candidly a practically efficient way to proceed.
Thank you. We'll adjourn court sine die and come down and greet counsel.
Thank you, Your Honor.
This honorable court stands adjourned, sign and die. God save the United States and this honorable